Well, good morning, everyone. Hopefully you can hear me now as I see you signing on. I'm speaking now, so you might want to check your speakers, make any adjustments you need to make. And we'll be beginning at 9 o'clock. Just doing a sound check for everyone. Should be able to hear me now. Glad to see, Eric, that we were worried after the holiday weekend that maybe someone would forget about the webinar this morning or be too tired or be off somewhere more desirable than in a webinar.
Right.
But they're showing up, Eric. That's a good sign.
I see we have a question in the chat from Michael about providing a link and a location for past sessions as he's missed a few. And so I guess once we get started, we can kind of have a little bit of housekeeping and kind of a reminder that we'll post these. We'll get everything posted once we wrap up the last session and share those links with everybody.
Yes, I just sent him that URL. Okay, I think it's 9 o'clock now. Are you good, Eric? Ready to begin? Everybody?
Yep.
All right. All right. Well, good morning and welcome to our, what is this now? Oh, this is session 4, as the slide says, our 4th webinar in our Solar Development in Ohio webinar series. Happy to see that we have a good number of you here this morning, ready to walk through the kind of complicated process of understanding how a solar project in Ohio goes through that oversight process or does not go through any oversight process, I guess, is the other side of that coin. So that will be the focus today, looking at solar project approval. And after we put out our marketing and materials on this, and I was preparing for this particular session, I thought I really should have used a different word than approval. We're looking at that process of developing a solar project and what kind of oversight is involved at the state and local level. So I think oversight would have perhaps been a better word, but that's the purpose of our webinar today. So I'm Peggy Hall. I'm the director of OSU's Agricultural and Resource Law Program, which is a program in the Department of Extension. I'm an attorney and I work extensively in the area of agricultural law. And as many of you know, solar development is certainly affecting many of our agricultural lands and communities. So I've spent a lot of time on this. I think Eric and I have gotten to know each other pretty well over the last 5 or 6 years working on solar development. Yeah. Eric, are you there? Yeah. You want to introduce yourself?
Yep, sure. Good morning. My name is Eric Romick. I am a Ohio State University Extension Field Specialist for Energy Education. So I do research, outreach, education statewide on energy topics ranging from oil and gas development in Eastern Ohio to some wind development in the northwest part of the state. We partner with a lot of both OSU research farms, but also private farms where we have advanced energy metering equipment, kind of looking at different methods of reducing energy cost on farms. And then, of course, as Peggy's mentioned, really since, and I would say 2016 to 2018, we started to see a transition away from a lot of interest in behind the meter solar projects that farms and businesses were considering. I say we, myself and colleague from University of Nebraska Extension have done a lot of financial modeling for farmers or businesses that are interested in investing in their own solar to see what is the payback on these projects. But that, as mentioned, that really kind of transitioned in 2016 to 2018 away from interest in that topic and just more and more questions related to utility scale solar development, utility scale solar leasing, the community impacts and regulatory environment associated with that. So again, appreciate everyone joining us this morning. And Maggie, I think you have the controls, right?
Yes, I do.
All right.
Yes. So land use, my involvement in solar energy began with the leasing question. We were approached by many landowners who had been approached by solar developers with solar lease potential. And so that's where a lot of my efforts first began in this field. But as we know, it has certainly developed into a land use issue. And so I've spent a lot of time on the land use side of solar development, and certainly recently looking at the possibility of zoning and what kind of local controls there are and the laws that have given more local control. So that will be the focus of today in this webinar. We'd like to see who's with us today. If you would take a minute, I know some of you have answered this question a couple of times already, but it does help us kind of tailor the presentation to those who are listening and making sure that we're addressing the different types of viewers who are on the webinar this morning. Looks like we have a lot of, again, Eric, local government and local government agency folks who are, I know, very much in the middle of dealing with this issue of solar development. And I see that being a good number this morning. Let me wait just another minute or two to get those responses in, and I'll show you all the poll results. Oh, we have quite a few others. If you want to let us know in the chat box what type of other you are, we'd be interested in knowing. Okay, I think I'll go ahead and share it now. Can you see that?
Yes.
Eric, okay.
Yep.
So you can see we have a diversity of folks here this morning, and hopefully we can address the different questions and needs you might have as we work through this rather large topic that we're all dealing with here in Ohio. So this has been part of our series on solar development. We're in session 4, solar project approval or oversight, and we'll cover application procedures, state and local oversight opportunities and regulations that are in place here in Ohio. Tomorrow will be our final webinar, and in that one we'll talk about what occurs after a project is certain to come into being. What about the pre and post construction issues that we're seeing in Ohio? And just a reminder, Eric and I are with the Department of Extension. We're academics. We try very hard, and I think we do a fair job of not taking sides on this issue, but instead focusing resources and informing those who are dealing with this issue and using our expertise and research to help inform that process. So let's go on to reminding you, as Eric said earlier, where we will have recordings of these webinars and We also have those other resources that Eric and I and other colleagues have created on the issue of solar development. You'll find all of that on farmoffice.osu.edu, which is a site that my agricultural law program shares with our farm management specialists here in Ohio. And we have a particular law library on that website. Within that law library is the energy law shelf or the energy law library. That's where you can find all of our resources. You will also find the recordings and the PowerPoint slides for these presentations that we've made. So all of those will be there. They're not there yet. I have the unenviable task of dealing with all of that. So downloading and trimming and putting those videos up for you. And so I'll be doing that after we complete webinar 5 tomorrow. You'll be able to go back and watch each of them if you missed any of them. So all on farmoffice.osu.edu. And also a reminder, as we've included this slide in each of our webinars on this series, that there are many different layers to solar development and the oversight that is in place in Ohio in that development process. And so we've been talking about one piece of that puzzle, one layer at a time, and trying to help you see how all of those different things can actually be kind of moving at different times at the same time, and how they overlap and interrelate with one another. And so we talk about lease agreements. Those are those early activities that we see in solar development, but we also have those other layers that the developer will be dealing with for the project itself, that approval to connect to the grid. Eric has covered that well in this series. And then we'll talk more about that approval to construct and own and operate the actual facility. And then there also are those tax processes and procedures that a development will also be dealing with as well, that will allow them to become a qualified energy facility and receive some of those tax exemptions. So there's a lot going on, and we hope that by going through this series, you're able to see that big picture and understand that there are many different parts to that can occur at different times, but that often end up relating one to the other. It's not always just a logical sequence, although it tends to occur in this sequence that we've visualized here in this slide. So in this session, we're going to talk about that solar development oversight or approval type process. And I'm going to approach this by dividing into large and small. And that's something that we've talked about several times throughout this series. So I'll be talking first about the procedures that are in place in Ohio law for those large, what we tend to refer to as utility scale solar facilities. So we'll be looking at the new authority to restrict on the county level any development of those large facilities, and to prohibit or limit those facilities if they do request to locate in your area. We'll be looking then at the Ohio Power Siting Board and their overview process for those applicants that come to them requesting that okay to go ahead and construct those facilities. So large will be the first topic that we'll cover, and then we'll look to small scale solar facilities and the new authority that we have in Ohio now for local zoning that can affect those small scale facilities. And I'll talk a little bit about zoning regulations, what we are seeing in Ohio, and some thoughts on how to address some of the issues that we see with solar development through those local zoning regulations. So that's the plan. So as you know, hopefully already by what I just said in the previous slide and throughout this series, we've highlighted the fact that in Ohio, the size of the project certainly affects oversight and the processes and regulations that apply to a solar project. So solar project differs, your solar project oversight differs according to that scale of the project. And we tend to look at utility scale with the Ohio Power Siting Board application process and the county authority to restrict or reject those utility scale facilities. We look at small scale and county or township regulations that can affect those small scale. I want to highlight here, you may hear the term, it's being thrown around a lot lately, community solar. And there is a difference to understand between community solar and community scale solar. I think those terms are getting intermingled and confusing people. But I think when we're using or hearing that term, I think Eric and I try not to use the term community scale solar because it is not the same as community solar. Community scale solar is really what we're defining as small scale, under 50 megawatt solar. But community solar is a different concept. That's a concept that allows subscribers to the system and net metering. And I'll talk a little bit more about that at the end of, toward the end of the webinar. But I just want to highlight right now that we're not talking about community solar. We're only talking about utility scale and small scale solar. So it's important to define those terms. Utility scale, if you look to the Ohio Revised Code, there are a couple of different terms used: major utility facility and large solar facility. And those are what we're referring to as utility scale. Two important things to remember there, that they're 50 megawatts or more, and there's a single interconnection to the electrical grid. That's a utility scale facility according to Ohio law. A small scale facility or a small solar facility under Ohio law is one that is designed to be less than that 50 megawatt line. And it also has that single interconnection point to the grid. So when we're talking about solar specifically, that 50 megawatt capacity is really the dividing line between what we refer to as utility and small scale. Those numbers are different when we're talking about wind, but for solar, 50 megawatts is the important number to keep in mind. And the fact that it is a system that has that single interconnection point to the grid. So Ohio laws have changed. I suggested that a little bit early on, that we have new laws in place in Ohio. And so what has happened is that, since 2021, very recently, we've changed authority and oversight of these projects. So before October 11th, 2021, which was when Senate Bill 52 came into effect, there was no county or township authority at all over these either utility scale or small scale projects. But Senate Bill 52 changed that as of October 11th, 2021, and we now have that authority in place in certain situations, and I'll describe those. And then a few years later, January 19th of this year, 2023, another new law became effective, House Bill 501, and that went even further in allowing counties, townships, municipalities to use zoning authority over smaller scale utilities. So we will explain that, but just keep that timeline and recognize that we're in the midst of change in Ohio, and we're still, I think, implementing some of those changes and understanding some of those changes as we look across the state. So let's talk about the utility scale now. We'll look at the first one, the 50 megawatts and over, and what is the process in Ohio for approving those solar facilities or not approving. We do now have instances where those projects have not been approved. We're looking at a couple of different things as we think about that utility scale facility. First is that county authority that is now in place as a result of that new law, Senate Bill 52, to designate areas that are restricted from any utility scale development. And that applies to solar and wind facilities. Then we look at another new process in Ohio, and that is a county pre-application meeting and review of a proposed facility. And then we'll look at the Ohio Power Siting Board and its regulatory process for reviewing applications for approval to construct a facility. And that's what you're seeing there on the left, my little visual here. You can see that regulatory body, the OPSB, did recently approve an application, this one being in Morrow County. That has been going on quite frequently now in Ohio, much more than we saw 6 or 7 years ago, that constant OPSB review process. So talking first about the new county authority granted in Senate Bill 52, and you can find this in the Ohio Revised Code in 303.58. And what that law now says is that the county commissioners have the authority to designate all or part of the county as restricted from either solar or wind large scale, utility scale development. So you can identify, it's a mapping. It's like creating a zoning map. It's actually contained in our zoning chapter for counties, but we don't call it zoning. We just call it the ability to create restricted areas, to designate restricted areas in the county where we know beforehand we will not allow solar or wind development at large scale, remember, within these areas. The Ohio Power Siting Board, that regulatory body, is prohibited. The law says if a county creates a restricted area from solar or wind, then the Ohio Power Siting Board is prohibited from accepting an application for a utility scale development within that mapped area. So there will be no ability, if the county restricts, no ability at all to apply for a utility scale approval to construct that project. But that process that the county commissioners would follow in order to establish a restricted area, and remember, it can be part of the county or it could be all of the county, that process itself is subject to referendum, and that was also part of Senate Bill 52 here in Ohio. So that means that those who live in the area, if they object to having that restricted area designation, can try to circulate a petition, get a sufficient number of signatures, and have that designation subjected to a public vote. So the petition requires at least 8% of the total vote that was cast in the last governor election to sign that petition as valid residents of that area. And this is a pretty fast track here that those who object to the restricted area designation are on. They have to act quickly and submit that petition within 30 days of the county commissioners establishing that restricted area. And then that petition would go to the Board of Elections to be reviewed to make sure it's a valid petition. And if it is, then it would go to the voters in that county at the next election, but it has to be at least 120 days from the date that the petition was filed. So timing becomes a little bit of an issue there. The project is on, if there's a project at all, no projects can locate during this period if it's under this referendum, because everything's a bit on hold. The restricted area designation itself is not effective unless a majority of the voters approve it in that referendum. This has happened across Ohio. I know. Now this was from August of last year, and we need to take account. I think Eric and I try to keep track of which counties are making restricted area designations. I think there could be a few more than when this article appeared last August, but at that time we had 10 counties in Ohio that were making solar or wind restricted area designations. I think a few more that are wind only than are solar and wind, but we have, I think, about 8 or 9 at last count counties that had made some type of restricted area designation, and more considering it even now, right now, as they deal with that issue of trying to understand whether they want that large utility scale development in their county or in certain areas of their county. So that's one thing. It's kind of the first.
Peggy,
Oh, go ahead, Eric.
yeah, we got a question. I think this would probably be a good time to touch
Okay.
on it as we kind of transition out of restricted zones into county pre-application review. So question in the Q&A is, for those who have paid their fees before SB 52 can be grandfathered in, is that correct or not? And yeah, this is something that I think we used to include quite a few slides on initially, because it
Right.
was kind of that awkward, phase in kind of period where you try and transition old rules out and new rules in. But initially they had to, so the Senate Bill 52 did not apply, or I guess you'd say the projects would be grandfathered if each of the following conditions were met, and that is that the siting board had conducted their compliance review and issued a letter of completeness for the application. The facility had entered PJM's interconnection queue and was assigned a queue number. They had completed their systems impact study and then at least paid the fee for their facility study. So, and what they were trying to do there was kind of gauge, once those projects were so far along in the interconnection review process, then they were kind of grandfathered under the old rules.
Mm-hmm.
But if
And
you
most
look
of
at
those have gone through now, Eric, right? Most of
most of
those
those
that
have
were
gone through.
completely grandfathered. Yes.
I think we still have a couple of them that are grandfathered, that are still kind of either pending or in the pre-application phase. But then most of them kind of met this condition where they were kind of conditionally grandfathered. So they didn't necessarily go through full county review where the county could say yes or no, like we do or don't support this. But what it did was it did require the local community had some local representation on the siting board's review
Mm-hmm.
staff for that, or the committee, I guess, for that project. So they had the ad hoc committee members that were included. So, and the siting board's site has kind of a status for each project, there's a column literally titled Senate Bill 52 applicability that kind of describes whether they're grandfathered or if it's kind of a conditionally grandfathered project that has to have the committee members on.
Good. Yep. And we try to check that and see where it is. That's readily available on the OPSB website, that you can see who's where in that process, whether a project does have that protection from Senate Bill 52 applying to it. And I think we also have to address just the legal concept of retroactivity of a new law. So it certainly is trying to walk that line and knowing at what point was a project, at a point in time where we couldn't retroactively apply this law to it. So we're really looking now with restricted area designation at those projects that are still coming forward, that have not arrived at that application phase or just recently arrived, as Eric described, and that involves, as he said, that interconnection activity that's going on as well through the PJM. So that's the first question. If I were a developer, and I know we might have a few on today who are from that development community, you're going to have to look at that. can we go where we want to go? Has this county taken any action to restrict utility scale development in all or part of its county? And I know we have seen counties that have done both. Some have just designated certain parts, some have gone the entire county. And so a bit of variety out there as we look across the Ohio landscape. So first question, is there a restricted area designation in effect? And then the next question is, will the county prohibit the solar project proposal before it even gets to the OPSB application stage? There is now new authority for a county to do that. And so before applying or amending, if there's an existing certificate, a certificate to operate a utility facility with the Ohio Power Siting Board, a developer now is required by law to hold a public meeting in each county where that facility would be located. And I've given you here at the bottom of each slide the Ohio Revised Code section where you will find these provisions. So that meeting has to be at least 90, but no more than 300 days prior to applying for the certificate. And this one I think is kind of interesting, Eric, the timing of that. You know, when they hold that public meeting, I've been thinking a lot about that and trying to understand how some of these projects might play out if they held a project meeting pretty early, you know, all the way, stretching it all the way up to that 300-day mark, and how that would affect any designations or county activity that was going on as counties were trying to decide what to do about this issue. But that's a requirement, at least 90, but no more than 300 days prior to submitting that application. They must give a written notice of that meeting to the commissioners and trustees in the counties and townships that would be affected at least 14 days prior to holding that meeting. And they also must submit a certain amount of information about that proposed facility. So what type of facility is it? What would its nameplate capacity be, that maximum capacity number? And where are you proposing to locate this facility? So a map with geographic boundaries for that facility. Once that meeting is held, there's kind of a stop and a go process that can happen at that county level. So the county commissioners may act within 90 days of that informational meeting. And there's a couple of options. First, they can just say, no, we want to prohibit this facility and pass a resolution stating that. If that's the case, then the Ohio Power Siting Board now has no ability to accept an application for that facility if the county has prohibited at that point that facility from locating within its county. So two ways a project cannot come to fruition pretty early. One is if there's a restricted area designation. This is the alternative. If when the project does come to the county and that hearing is held, the county commissioners say, no, we don't want it. That will kill it. It can't, the Ohio Power Siting Board has no authority to accept an application from a project that has been prohibited in this way by the county commissioners. The second option is that they can limit the geographic size or the land used for that facility. So they could pass a resolution saying, we only approve it if it's this size. And then the third option is that they take no action at all, that they just let it go by. And so in those cases, that's the green light that you may proceed and go ahead and file your application to the OPSB. And that application then has to be the same as what that developer presented to the county. They can't present it and then change it and submit something else to the OPSB. It has to be that same project. The OPSB, once that application is complete, then would notify those county commissioners and a representative from the county commissioners as well as from the townships that are affected would then be placed on the committee that would review that application. Those are all new parts of Senate Bill 52, and I've given you the different, as I've gone through this, the different sections where you can find these new provisions that are in place. So that's that county pre-application review process for a proposed facility. Then we go to the Ohio Power Siting Board. So if the county hasn't either restricted an area or prohibited that project from moving forward, then the developer would go through the Ohio Power Siting Board and that application process for approval to construct and operate that facility that they're planning. The Ohio Power Siting Board's website is just an amazing source of information. So I'd encourage you to go here. That's what you're seeing now. If you do want to find information about what's happening, the big picture in Ohio, they have wonderful maps of Ohio and showing you what's happening where. Or if you want to go into a particular project, you can see everything that's been submitted for that project. You can follow it, track it as it goes through this process that we're going to work through now. There's this solar mapping application down here toward the bottom of the page that I would encourage you to take a look at if you want to learn more about what's happening, again, either statewide or within your area. So this is all based on the Ohio Revised Code and the Ohio Administrative Code, our statutes and our regulations that tend to fall under this category of power siting and public utilities. So we're in the Ohio Revised Code here in chapter 4906. That's where a lot of the laws that lay out this regulatory process are located. And then you'll also be seeing some provisions from the regulations, the Ohio Administrative Code. And you can see here that there's a particular section of the code that the title explains it pretty well. A certificate is required for construction of a major utility facility. And remember, for solar, that's that large utility scale 50 megawatt number that we're looking at there when they say major in this context. So the administrative code provisions are over in 4906, and those go into a little bit more, or a lot more detail actually, about what those applications look like when you're applying for that certificate that would allow you to construct and operate that large scale facility. So a lot in 4906, and we'll be looking at some of both of those, the statutes and the regulations. So this is all under the purview of the Ohio Power Siting Board. That's an independent body that's within the Public Utilities Commission here in Ohio. And the role of that body is to review those applications for certificates and determine whether to grant a certificate. It's the full name, the official name of it is a Certificate of Environmental Compatibility and Public Need for a major utility. That's what allows it to proceed and be constructed and go into operation, is receiving that certificate from the OPSB. So OPSB's role is to review that application and to assure that that facility that's being proposed meets the public need, promotes the state's economic interests, and protects the environment and land use. So that's some of that statutory language that you'll see in regards to what the role of this board is. There are now a few more members on the OPSB, and we can delineate between voting members and non-voting members. So the non-voting members are members of the legislature, 2 from each side of the legislature, 2 from the House, 2 from the Senate. They do not vote on the applications, but they sit on the board. The voting members, as you see here, are the heads of our agencies here in Ohio, the EPA, the ODA, Director of Agriculture, the Department of Development, the Department of Health, the Department of Natural Resources. Those are all heads of those agencies, and along with the chair of the PUCO, and that chair of the PUCO serves as chair of this board. So we have those agency folks, and then we have a public representative who is an engineer. That person is appointed by the governor, has to be approved by the legislature. And then we have those new local members now. Those are going to change with every project. So local members, one county commissioner and one township trustee, will be appointed for a particular project based on that geographic location of the project. So those two members always in flux, but the others being those directors of those agencies, and then the legislative members who, as I said, are non-voting members. So they sit on the board and their job is to review these applications. So, Eric introduced me to this visual a couple of years ago. And the first time I saw it, I thought, oh my goodness, wow, that's a lot to take in. But this is the flow chart that you'll find on the Ohio Power Siting Board. They've done a nice job of pulling together that process that plays out when a developer applies to the OPSB to receive that certificate. And so you see all the steps here. And if you're interested in this, I would encourage you to go to their website and pull it up, because all of those parts of the code or regulations, they're all hyperlinked and you can go directly to them from this flow chart that they have on their website. And just following the boxes and the arrows can tell you a lot. Now we don't have the time to go through every little detail, but you can see here that we begin with a pre-application conference and the steps that have to happen as we go through this whole process of submitting all of the information that is required to be submitted with that application, moving forward, having a complete application, having it reviewed and investigated by staff at the OPSB. And I should have mentioned that in the previous slide. We have the board, but we also have an incredible staff that works there at OPSB that is heavily involved in reviewing these applications. We have public notice requirements, as you'll see here, public hearing requirement, and then we go to that adjudication, that kind of quasi-judicial activity that occurs as the board hears about that project, reviews all of the information, reviews the record, reviews what the staff has to say, and then ultimately makes a decision on whether to issue that certificate. And as you can see here, it's either issued or it's denied. And then we have rehearing and appeal rights that come after that. So that really lays out the steps that the applicant must follow to get through and receive that certificate. This is a nice visual that someone at the OPSB developed, and I think this makes it a little bit simpler to understand the process. But once it gets to OPSB, now this doesn't address the new county authority that exists prior to OPSB, but once it gets to OPSB, you can see that there are these kind of 6 steps that they see the project going through, 6 major steps, from pre-application to submitting the application and getting a letter of completeness that everything is here. And now we're ready to investigate and review that application, to the hearing process there in step 4, to the actual decision by the board, and then to possibly rehearings or appeals that would come last. So I really like this visual in simplifying the flow chart that we saw in the previous slide. So let's look a little bit more closely at an application process. Here's an example of a case. This is that case that was just recently approved in Morrow County. And you can go online, as I said, and look at a specific case. And I would encourage you to do so, because it's very educational to see what that developer is submitting, to see all of the information that they're required by law to submit, and to read in detail what their thoughts are, what their design is, how they're going to handle different issues. And you can see here a case. I've given you an actual case file. So imagine this is the big folder with all the paperwork in it that this developer has submitted to the Ohio Power Siting Board as it strives to obtain that certificate. So a lot of information that you can see in this case file, and this is all subject to review by the board. So what has to be in there by law? Well, we go to the Ohio Revised Code and you can see requirements. The language is shall. An applicant shall file this following information. And you can see quite a bit here. You know, they have to describe the location, a summary of studies they've made about the environmental impact, a statement of need for that facility, a statement of the reasons why this location is conducive to that facility, how it fits into the overall picture, and other information that the board may require. And that other information is going to be in the regulations. And you can see here an example. We go over to the regulations, and the board has created additional requirements beyond those more general requirements that are in the statute. So application contents, here's an example of just one. When we're talking about health and safety, land use, and ecological information. And this is not the entire regulatory language, but I just wanted you to see an example of, we do go into more detail than what you see over in the statute. We go into more detail in these regulations. So the applicant shall provide information on health and safety. And then it starts going down through different provisions there: equipment safety, air pollution control, noise, and so on. So a lot more detail over there and what has to be submitted into that case file. And you can see here, again, an example of what this developer had submitted in response to those statutory and regulatory requirements. A lot of exhibits and plans that I've highlighted. Whoops, it looks like my highlight's a little bit off. A landscaping plan, a visual assessment, a cultural report, a historic report, a work plan. All of those kinds of documents are appended basically to that application and included for review by OPSB. So a lot of detail. And look over here on the right, you'll see, you know, the number of pages of some of these documents can be a little bit hefty. That's where the OPSB staff comes in, because they will review all of that information. Now, also in that file, and this is something that Eric and I we're talking about earlier before we started the webinar, just the language of the Ohio Revised Code is actually that they have to submit this at least 60 days prior to beginning construction. But the practice, as we've seen, even before Senate Bill 52, this is part of the change that came with that, was that a developer would go ahead and submit their decommissioning plan, basically, within that application. But the language of the Ohio Revised Code is they don't actually have to submit it until at least 60 days prior to construction, the actual plan for decommissioning. But decommissioning is addressed within the application as well. So this is a change that I just want to mention, and we'll be talking a lot more about decommissioning tomorrow in that webinar that we'll be doing. But Eric, do you want to talk a little bit about decommissioning? I know you're so well versed in this area.
Sure, happy to.
Good.
One of the things, maybe before we jump into the decommissioning, Peggy, just as a really good summary of the siting board and the various revised code language and the administrative rules. Just a quick reminder, I know on slide 18, you showed kind of a screenshot of the Power Siting Board website. For anyone that's interested in doing a kind of a deep dive into the into the administrative rules and kind of looking at in more detail all of the different criteria that's required in those applications, there's a tab at the top of the siting board website for that says rules, and then from there you can go into the revised code um, to see kind of where that legislation's housed, or on the administrative code side to kind of look at the siting board's rulemaking for that process. So a really good resource that kind of lays it out so you can kind of easily navigate through and try and make sense of what's required and at what point in time and why and from who. And so anyhow, so yeah, decommissioning, as as Peggy kind of indicated, there is the requirement now that 60 days prior to construction, the applicant submits a comprehensive decommissioning plan to the siting board for review. A couple things to kind of mention or build on that is that plan has to be prepared by an engineer that's registered with the Ohio State Board of Engineers. The siting board does reserve the right to require the applicant to choose a different engineer if they so choose. And then the plan needs to kind of outline all the parties involved and kind of a schedule of these decommissioning activities that need to take place within 12 months of when the facility ceases operation. So,
And I guess, Eric, we should clarify what we mean by decommissioning. We use that term so much, but we're talking about the end of life, when it is to be taken offline and taken down.
yeah, and the language often refers to de-energizing the system and safe removal and disposal of the key components. So so as we think about the decommissioning plan, I think there's some animations in this slide. I don't have controls, Peggy, but
Let me
a couple of things that we've seen over time is this idea of net decommissioning costs. And so prior to Senate Bill 52, it wasn't a requirement that developers submitted decommissioning plans. However, some of them did. And if you went and looked through them, they often reference this net decommissioning cost, which is essentially kind of looking at the full cost of decommissioning that project minus any of the decommissioning revenues, which essentially are tied to salvage value of recycling certain components. We'll look into this a little bit more detail tomorrow. We have a couple of examples of kind of what this language might look like in a lease agreement. We have a couple of examples of decommissioning plans that have assigned values to the salvage and recycling side of some of these components. But Senate Bill 52 does not allow the decommissioning cost to include salvage values. So it is the cost of removal is the cost of removal, and that's an important protection that's provided in Senate Bill 52 as it relates to end of life decommissioning. The other thing that we'll talk about a little bit is you can see on the slide there that it references this restoration of the land on which the facility is located to its pre-construction state. We'll talk about that a little bit more tomorrow as well. But there's certainly some more protections for communities and landowners as it relates to making sure that we have good rules in place that is estimating the cost of removal and not artificially deflating that value. The other thing, as you can see, it requires the engineers that put this decommissioning plan together that they reevaluate that every 5 years to do recalculation of those decommissioning costs. And so, periodically every 5 years, they'll have to update those costs. Next slide, Peggy. So a common challenge or question that we would hear from local communities and landowners and neighbors is, what happens if, the project goes sideways some way, the developer or project owner is not able to properly complete their decommissioning. And, prior to Senate Bill 52, there was a requirement that you described how you were going to set aside, securities to make sure that the decommissioning could be carried out. But it didn't necessarily go into as much detail as what we do now with Senate Bill 52. So with SB 52, it's requiring that prior to the start of construction, the applicant post a performance bond that's equal to the decommissioning cost that's outlined in their plan. So we just talked about on the previous slide that as that decommissioning plan is submitted, they have to estimate the cost of removal. And again, the cost of removal is based on the full cost of removal, no salvage values. They need to name the siting board as the bond obligee. And then the last piece to this is that, as we reevaluate those costs on a 5-year cycle, if the estimated decommissioning cost increases, then the performance bond to have that project decommissioned also needs to be increased. In the event that the estimated decommissioning cost goes down, the performance bond stays the same. So, two things that, kind of to summarize that they really addressed with SB 52 is number one, the cost of decommissioning that is assigned to these projects is based on the full cost of removal and not including any salvage values. And the other key component of this is that those performance bonds need to be set in place prior to construction starting. Whereas in the past, we saw some different language that sometimes was tied to, in the year in which the estimated
Year
cost of
15 or
decommissioning exceeds the estimated salvage value of assets on site. And there's just some kind of creative language that maybe didn't necessarily have the same protections that exist if that's in place before you start construction.
Good. Thank you, Eric. I think that's a nice overview of decommissioning. And as he said, we'll talk more about that tomorrow. But that decommissioning plan, you may see it in the application, even though the language says it is not required until up to 60 days. But I think at that point, because they're addressing decommissioning, they go ahead and include the entire decommissioning plan and meet those new statutory requirements that Eric just outlined for you. So that gives you an idea of what would be in that application that is submitted to the OPSB. And I want to mention too that Ohio law requires other parties to intervene or to be a party to this actual case that the OPSB is reviewing in order to make that determination. So there is a right of intervention, and we do see other parties take that action to intervene in the case and be able to know what's going on, and also to have a role in those legal filings that are permitted within that case. So there are certain, as you see there, the executive officers, of municipal corporations and counties and heads of public agency have the right of intervention. But look a little further down and it says all other persons may petition for approval to intervene as a party to the case. And so we have a petition process for those parties that want to join in and be a part of the case. And then the administrative law judge who is overseeing that case, because it is a quasi-judicial type hearing, there is an ALJ, as we call it, judge that's kind of overseeing that hearing, even though the board makes the decision. That judge will review those petitions and decide whether or not to allow those other parties to intervene in the case. And you can see that there's a requirement that you have to show a good reason, good cause for why you should be allowed to be a part of this case. And so they'll look at these factors that are listed here in the regulations that say, if we're going to look at the nature and extent of the person's interest, the extent to which their interests might already be represented by parties in the case, their contribution to a just and expeditious resolution of the case, and whether granting that intervention would unduly delay or unjustly prejudice an existing party in the case. So we do see that a lot, where concerned citizens, townships, counties, organizations will request to intervene and be a part of the case.
Peggy,
So,
I have a
yep,
question in the
yes.
box related to that. So are intervening parties limited to adjacent property owners?
No, that would, the law doesn't say that, but that would be part of the argument you would make in your petition, that you are an adjacent property owner, and that you want to make sure that your rights would be protected. You aren't automatically granted, so you would be subject to the review by that judge and a decision as to whether you could. But non-adjacent owners would have a similar right. So once we have that application together, the role of the OPSB is to review the application. And we're going back to the statute now that says the board shall not grant the certificate unless it can make all of these determinations. So unless it finds and determines that every single one of these exist. Now, when we're talking about a solar energy facility, the first one doesn't apply, but you can see the other factors that the board must make a finding and determination on. So the nature of the probable environmental impact, that the facility represents the minimum adverse environmental impact, that it's consistent with regional plans for expansion of the grid, the electric power grid, that it complies with all applicable laws for air and water pollution, solid waste disposal, and air navigation, that it satisfies the public interest, convenience, and necessity. That's a big one when we're talking about some of these community issues that we see. Number 6 becomes highly relevant. Does that facility meet that factor? Number 7 is what the impact will be on the viability. Now, you have to be careful when reading this one. The viability of agricultural land in existing agricultural district that would be located within that site. So we're not looking at agricultural land around that facility. We're only looking at agricultural land within that proposed site, and whether it's enrolled in Ohio's agricultural district program, which we also refer to as our right to farm law. But that is land where the landowner has shown an intent basically to hold that land as agricultural land and receive some of the protections Ohio law affords landowners for doing that. So we're only, remember, looking at land within that proposed site for that factor 7 there. And then finally, the last factor is that they've incorporated water conservation practices, maximum practices. So that's all in the minds of these board members as they review an application. We've got to go through each of these and make a finding on each of these criteria. But what happens with the OPSB staff is really useful to the board making that determination, because after that application is complete, and it's all there now, that's when the investigation stage of that scheme that I showed you begins, and the OPSB staff will investigate that application. So they'll go through all of those documents. They'll try to understand what is happening, what is proposed, what is this applicant proposing to do, what studies have they completed, what are the results of those studies. They'll go through all of that information, and their job is to make a staff report and a recommendation to the board. So they're the technical people behind the scenes that help the board understand that application and make that decision and go through those criteria that it's required to review. So the staff report can be incredibly useful. And Eric and I, this shows you how kind of nerdy we are. We've sat together and looked at staff reports and read pieces and parts, and a very, very useful, informative document that will be within a case. And I've given you some pages here from that recent Blossom solar project that was just approved. And you can see what is within that staff report. They'll lay out the project first, and you see a map here, but then they go through many other pieces and parts and make recommendations to the board on what they, as the technical experts, think should happen here. So here are a few other pages from a staff report that would be filed during that investigation process. And you can see that they're really reading through reviewing everything and analyzing it and making comments, considerations, suggestions, and even down here, finally they'll say, we think you should or should not grant this certificate. Often they'll say, well, you should grant it only if you would include these conditions within the certificate. So we want some additional requirements, and that's what you're seeing over here. So that gives you an idea of that investigation phase that occurs once that application is complete and submitted. And then we go into those final 3 blocks. The hearings, I'm sure many of you are familiar with the public hearings that take place, the actual decision that the board must make then on that application, and then some rights for that applicant to request a rehearing or an appeal. I'm not going to go into as much detail on those parts because I really wanted you to get a sense of what has to be submitted and how then does the procedure play out in order to make that decision whether or not to approve and grant that certificate. So there is the public hearing requirement, and you can see here that there is a judge that would oversee that. That same judge that is appointed to that case. Usually they try to put those in the location, but not always. Sometimes they can be where, at OPSB spaces, but they try to put those near. But the requirement is that it doesn't have to be at the location, but what the practice is that they try to make those out where the project would be. And then you can see that after that hearing is held and the comments are reviewed, then we have the decision by the board. So that puts us into that 5th block in that schematic that I showed you. And it has to be made within a reasonable time. Attorneys love that word reasonable because we can argue all day over what's reasonable for a certain situation. But if you remember that schematic, they do try to keep those moving along on the timeline within a few months after that hearing is held. The OPSB will issue its decision. And then let me go back here for a moment. You can see here that, that the board has to review all the evidence, the application, and make a decision. It can condition the certificate and create, these additional requirements. You didn't propose this, but we're going to require this. And your certificate is only effective if you meet those conditions. They require you to meet those. And then they'll make that decision and enter it. So it's an official decision. If the applicant or the parties of record in that case do not agree with that decision, they have a right to request a rehearing with the OPSB, but there's a little bit of a misunderstanding about this. The rehearing is really saying, we need you to hear it again because you didn't get all of the information or something was missing, or it's not just, oh, we don't like it, period. There has to be a justifiable reason for requiring that, or for granting that request for a rehearing. And you see some of that language in there. An application for a rehearing must set forth the specific grounds upon which they consider that decision to be unreasonable or unlawful. In order to do that, you may need to make some arguments, about information that needs to be reviewed or was missed, or even additional information that maybe could be obtained to help with that. So rehearing request is one right that applicant or any party has. And then we go back through that adjudicatory hearing process for the board to look it all over again and make another decision. But also, the parties have a right to appeal the decision. If we have a final order by that board, then they have the right to appeal directly to the Supreme Court. So we don't go at those lower trial court levels. We go directly to the Supreme Court, and this has happened. We have, I know of at least one solar case right now that is in front of the Ohio Supreme Court on an appeal of a rejection. And actually, I believe that's my next slide. Here we go. So we have had some of these applications denied and a certificate denied, not granted by the OPSB. In all of these cases for these 3 projects, the reason was that that criteria that I pointed out in number 6, the 6th criteria about whether the facility will serve the public interest, convenience, and necessity. And in all 3 of those cases, the board decided no, it would not. And that was largely due to pretty vocal general opposition by the governmental bodies involved in that project area and the citizens and residents that live in and around that project area. And the board, considering all of that evidence about that opposition, decided that the project then would not satisfy that 6th criteria of serving the public interest, convenience, and necessity. And so those are all, there were rehearing requests, and the Kingwood one, the number 2 project that I've listed there for you, is now actually on appeal to the Ohio Supreme Court. So we're keeping an eye on those to see what will happen, because this is a new development to see the board deny a project on that criteria A6. We've not seen much of that in the past, so we'll keep an eye on that. Okay, so that wraps up the utility scale. Let's move on. Hopefully we can finish on time. Eric and I are not good at finishing on time when we start talking about solar development, but this is a little bit shorter because there's less involved when we're talking about those small scale solar facilities that are under that 50 megawatt dividing line. So what happens there if we're looking at that type of project? Well, a little bit of history here. Before House Bill 501 came along and became effective, as I noted earlier, counties and townships were very limited in regulating a smaller scale solar facility if it could meet that definition of a public utility. That's because there's an exemption in Ohio zoning law for counties and townships that say you have no zoning authority over a public utility. And there's a policy reason for that. The state doesn't want local governments interfering with that very important need to provide public utility services. Well, that big exemption has now been scaled back in the instance of these smaller facilities. And we now have new law, and this is what came in House Bill 501, that says as of April 6th of this year, we are going to basically negate that public utility exemption when it comes to small solar facilities. And we're going to say that you do have the ability to use local regulations in regards to these small facilities that are under that 50 megawatt mark. So we now have the ability to regulate small scale facilities at the local level through zoning because of House Bill 501. So here's what the language actually says, that we're just going to disregard what we said earlier about the public utility exemption. And we're saying that the statutes that the Ohio Revised Code does confer power on a board of township trustees, and you'll find this in regards to counties and municipalities as well in their appropriate sections of Ohio law. But it does confer power with respect to the location, erection, construction, reconstruction, change, alteration, maintenance, removal, use, or enlargement of a small wind farm or small solar facility. So new power now granted at that local level to use zoning in regards to those facilities. So what's interesting, I think, historically about Ohio is there already has been some model language floating around the state and adopted by a number of townships and counties and municipalities that does address small scale solar, despite that public utility exemption. And there's a good reason for that, that perhaps that small scale solar is not really a public utility. And so townships and counties and municipalities did adopt language that would address zoning for small scale facilities that may not have been public utilities, and we wouldn't have run into that public utility exemption. So we do have existing language in many of our zoning resolutions and ordinances across Ohio that address these small scale facilities. So what do those zoning regulations look like, and are they sufficient? I think there's an important question here to be raised. Do those regulations address what we are now experiencing in Ohio? And that is a different kind of small scale solar development than perhaps they envisioned when they adopted their zoning for small scale. They may have just been envisioning smaller scale solar that would be built by the landowner for their own needs, where now we're seeing small scale solar that would be on leased land and connected and the power provided elsewhere. So do these existing regulations, I think, address those needs of this type of development is an important question. But the common approaches that you see here on this slide is that the zoning resolutions tend to distinguish between the type of system. Where is it? Is it a rooftop system? Is it a ground system? Is it integrated into the infrastructure itself? The model language that circulated around the state distinguished between those different systems and then treated them accordingly in the zoning regulations. So they would determine the zoning districts where maybe this type of system would be permitted, and designate those areas. Okay, we'll permit rooftop systems here, but not here. So permitted use designations. And then we also see that many of them include conditional use regulations, where we look at the zoning districts, we look at the different systems, and we decide, are we going to make it a conditional use that we will review and determine whether we will allow that type of system in that district based on what's proposed and based on whether it's consistent with the character of that district where it's locating. So the conditional use permit is something that I see in the zoning resolutions and regulations that have already been enacted in Ohio. That gives a little bit more control over the permitting process for solar. So when we look within those zoning resolutions, I often find that there are some general standards that address, well, these systems, need to be under this height, can only cover this much of the lot, visual buffers, and usually those are vegetative buffers, sometimes fences need to be in place. We need to address lighting and noise, setback requirements from property lines or other residences, maintenance requirements. What happens if operations cease? There usually is some kind of requirement that it needs to be removed if it's not operating. Some of them require that a building permit would have to be obtained. And interestingly, many of them prohibit advertising use on these systems. I think that's really targeting more toward wind or something that might serve as a good advertising vehicle rather than solar. When you look a little more closely when a township or city or county is using that conditional use permit process, there can be additional detail and requirements within that conditional use permit and what the applicant would have to submit for that. And so you might see that they require a road use maintenance agreement. So if you're bringing a lot in to construct this and maintain this, we may need you to agree to some conditions regarding maintaining that road that you'll be using. We may need you to prove that there are safety services that can address this system. So fire response certainly being a concern there. We may require that it only be located in certain areas. I find many that say only in the backyard. So, really looking more at a kind of a smaller residential system. Height requirements there again, and buffers and setbacks. Certainly in regards to residences, we see that there are often provisions in there. And then some other provisions that might address some of those, what we tend to think of as inconvenience or nuisance impacts like glare, lighting, and fencing. So different standards in place in the existing or the model resolutions that I've reviewed here in Ohio. But as I said, there's a bit of a question, is it enough? And so as we look at the permit process itself, there's often a requirement or two built into that saying that you have to submit an engineering report that really shows us what you're doing. So what's the size of that system, its height, and its generating capacity. So looking at the megawatts there. And what are you going to do with hazardous materials that might be contained within your system? How will you contain those, and how will you dispose of those in the future? A site drawing is often required by that permit application process, as well as a maintenance schedule. So making sure that it continues to operate, and what is often referred to as a dismantling or ceased operations type plan, which connects to what Eric was talking about, decommissioning, taking that system down. So we do see those additional bits of information that kind of echo some of the parts of the OPSB application process that townships and counties and cities are asking for when they apply for a zoning permit. Give us this information so that we can decide whether or not to grant that permit. But as I mentioned, is that enough for what we're seeing now? Those model zoning codes and actual adopted zoning resolutions out there across Ohio, I think many of them were adopted prior to the solar development activity that we're seeing now with larger facilities. And so do those existing zoning regulations address some of the needs and issues that communities and landowners and local governments are having with slightly larger scale, small scale, and small scale that is going offsite and is not just feeding that landowner's needs. So here are some of the other provisions when we start thinking about kind of best practices or recommended practices, or you'll hear the term smart solar oftentimes. These are other provisions that appear in some of those kinds of land use controls or regulations. So protection of prime or unique or locally important. There are different language and definitions we can use there. We sometimes need to consider that. Do we want to include that we're not going to allow development on certain soils? That's something that we've been hearing over and over again from the agricultural community. Are we losing our best soils to solar development? The zoning resolution could address that and not allow it on certain soils as part of that conditional use permit, or even as a prohibited use in certain areas. We also see a lot of interest in, let's try to locate these on brownfields or distressed sites, or sites that are better suited for this use rather than consuming our agricultural lands for this use. We could see some grading and soil removal standards. There's been a lot of consternation brewing across Ohio with projects that are under construction, and a lot of surprise and frustration with the extent of grading, the extent of compaction, the soil removal processes that are occurring out there. And then also drainage, of course, is a major concern in our agricultural community, but can also be in those more urban areas where we're looking at some of those, public systems and stormwater management. Are we going to address drainage and drainage mitigation, both surface and subsurface? Noxious weeds management is something that we hear over and over again as a concern, certainly in the agricultural communities that try to maintain those noxious weeds. So that could be something that's addressed within the zoning. Co-location with agriculture, and you see here a photo from a gentleman I met in Colorado who has installed a system on his ranch out there and is experimenting with growing all kinds of agricultural crops within the confines of his project, which is a smaller project. And you can see there, he seems to be doing pretty well, pretty productive. So are we going to require some co-location? Are we going to incentivize it? What about other land uses other than agriculture? Do we want to co-locate with parking lots or those kinds of land uses? So that's something that some address through their zoning. Pollinator habitat provisions requiring that perhaps that vegetation, if we're not in a co-location that prevent it, that vegetation be pollinator habitat. Addressing historic or culturally significant sites with, and most of those tend to avoid. We just have a flat out, we need to prohibit development around any historic or culturally significant sites. Some look at residential density and say we aren't going to allow it if it's within X feet of this many people or homes or those kinds of provisions. And then finally, a little more detail on decommissioning than we see in the zoning that I've reviewed in Ohio that's been adopted. A little bit more onus put on that owner of that system. Some of the current regulations put the onus on the landowner, so that's a bit frightening. We want that burden to be on the owner of the system for removing and restoring that site after taking it down. And I want to make a final point here as we're nearing the end of the webinar. Going back to what I said earlier, we have to remember that community solar is not the same as small scale solar, even though community solar can be small scale, but community solar is actually a legal term of art. And in Ohio currently, we do not have the authority for community solar projects. And I say this because I know many landowners have been approached by developers or landmen who are saying, hey, we want to lease your land for community solar. And to be fair, it sounds good, right? Sounds like a nice thing. Community solar sounds a little bit more palatable, I think, than utility scale solar. We're going to just put a small project in that will benefit your community. But legally, community solar is a net metering type concept, and we do not have the authority in Ohio for community solar to take place. And that's because of the way our public utilities have been built out over the years and the rates that go into supporting that infrastructure for those public utility systems. So when we're looking at community solar, what the I guess the vision of that is that we're going to develop this smaller system and allow subscribers to this system. So it is a net metering type process. So it would allow the subscribers to use that energy and there'd be net metering that would take place. Well, under current Ohio law, the only net metering that is authorized is if that generation is on the ratepayer's own property. So once it leaves, net metering is not permissible under Ohio law. So we require a change in Ohio law if we're going to allow this kind of community solar that would give, that net metering benefit to subscribers to that energy. Now, there was a proposal last session, House Bill 450. It did not go anywhere. It was not passed, was not adopted. It kind of limited the size of community solar projects, allowed it and certainly encouraged it more so on brownfields and distressed sites up to a certain size. But it was opposed for this kind of net metering reason that, wait a minute, you can't let these people out of paying for the infrastructure.
A lot of times, Peggy, that's a lot of people are referring to the concepts with community solar as virtual net metering.
Oh, that's a good way to describe it.
Because under current law in Ohio, like for net metering, the generation equipment must be located on your own premises, whereas this would be the opposite of that concept, right? This would be the generation components existing somewhere off of your site, but then you virtually contract through billing to you pay a fee schedule and essentially get the generation from a portion of that project. However, they may design the billing for that. But virtual net metering is a term that's used a lot with community solar. But yeah, as you mentioned, we don't have that in Ohio.
We don't have that authority for that developer to be able to do that type of project, even if it is a smaller scale project, which they do tend to be. So just keep that in mind. If you hear community solar, we're not there yet. There are about 20-ish states across the country that do allow that kind of net metering for on-site or off-site consumption, but not yet there in Ohio. And I don't know if we'll see another proposal, because the two who proposed House Bill 50 to the two representatives are no longer in the House. So whether someone else will take up that initiative, I have not heard. Okay, so that concludes. Hopefully I gave you a good oversight. Coming up tomorrow, we'll kind of pick it up from where I ended and look at, okay, if an application is approved, what happens next? Eric?
Yeah, and that's really good overview, Peggy. And I decided to kind of hold questions again as we were starting to kind of come up against the time. So we do have a number of questions in the chat box that we can start to work through here if you're ready.
Sure.
Okay, so the first one is, so how do we protect our land from companies going bankrupt or forfeited?
Yeah, and I think that's a common concern in any of these situations, just, regardless of the scale of that project. But that's where the bonding requirements can be helpful. Some of those zoning, if we're looking at smaller, definitely the decommissioning in the larger, those are all going to be helpful. But as I kind of harped on a bit, I think in session 2 on leasing, we also need a strong lease and strong lease language so that we're doubly protected in regards to those concerns that landowners might have. You've got the governmental role, oversight, that authority that comes through either OPSB or the local zoning, but you also have the landowner having its own enforcement mechanism, and that is the lease. So strong provisions within that lease would be the other part of that protection. Is that enough detail there, Eric?
Yep,
Okay.
I think it's really good. So next is, do intervening parties have input on the conditions of a certificate?
Yes, actually, many of them. A common intervening party that we see is Ohio Farm Bureau. They often intervene and they review everything, and they make their own kind of report similar to the staff report, where they'll say, here are the conditions that we think need to be imposed. And sometimes it gets into a bit of a settlement process that occurs where they're negotiating all of the parties and trying to come to an agreement on, yes, we'll agree to do this. Those kinds of activities occur within that case context.
Yeah, good. Okay, so for small scale renewable energy developments, would it be a violation of Ohio ethics law for either a county commissioner or township trustee to make a decision or act in their official capacity regarding the development if they have personal and or family financial interest in the development? There's a lot there.
Right, there is, and that's an excellent question. It's not one that I've researched extensively, but I will say that my initial reaction is no, they would need to recuse themselves from that. And there is actually a provision where in the process that we now have before the Ohio Power Siting Board, where we appoint the 2 local officials to that review committee or the board, there is some statutory language that says that, if you're an intervener, you can't be the person that's appointed to the review. So there's a little bit of a precedent there for addressing that issue. I want to say yes, Eric, but I want to condition that with the fact that I haven't thoroughly researched that issue, but it's something I think I should look into. But my initial reaction is yes, we could have an ethics problem there.
Okay, So I can probably try and help out with the next one. So the next one is, I see that glare could be a potential, or listed as a potential issue. Wouldn't this be an issue with utility projects, especially close to airports? There's actually a lot of information on the Federal Aviation Administration's website. I think it's in 2021 or 2022. Recently, they've issued new policies on solar projects at airports. And I know that they have like a technical guidance for how to evaluate the glare on those projects. So that's definitely something that the FAA is addressing and looking at.
Good. And that provision is in there. You know, they do note that in the OPSB process that we do look at air navigation as part of that application,
Yes.
air navigation impacts.
So the next one is there a hazardous material site for the solar panels to go to in Ohio? So I think this kind of gets to some of the stuff we talked about. I think it was in session 1 where we talked about how, in fact, most of the modules, and again, I'm not stating all because, certainly, every module is a little bit different, but I think it's fair to say most of the modules do pass the EPA's TCLP, toxic characteristic leaching procedures test, which in effect is determining whether it's considered hazardous or non-hazardous material. So being that they pass those standards, it's considered non-hazardous material in most instances. That's not to say that there might not be a module out there that doesn't pass that standard, but most of them do. And I'm not aware of a specific site in Ohio for those panels to go.
Neither am I. No.
Okay. Next, do utility scale solars have the same guidelines as small solar zoning, such as noxious weed management, protection for prime or unique farmland, I think is what they're getting at, local soils and such. So I think the genesis of the question, I think, is kind of, do utility scale solar projects have the same guidelines as small scale zoning projects? So
Yeah,
you
I
want to
think
take
the
that?
question is, could they have the
Good,
same?
right? Because
Right. Um, as I look across the landscape of what we do have in Ohio, not many of those small scale provisions have the same requirements that the utility scale
and
application
and
requires.
and I think maybe sometimes overlooked first step is, the requirement that your county or township has established zoning to begin with, right? There's still some areas in Ohio that are unzoned.
Definitely, yes. Yeah, and that's the fear, is that those communities have to go through the whole process of enabling zoning before they can actually have solar zoning. So different process there. But I think this brings up what you and I were talking about earlier, Eric, that a good guideline for zoning regulations is to look at that OPSB process and look at what they're addressing, because
Mhm.
they have done some of that homework already.
Yep.
And even as we're going through this now, they're changing some of the rules in Ohio that do create some additional requirements. So looking at what those issues are, and they are those needs that I pointed out that maybe we could include in the small scale, things like drainage and protecting soils. And now when you look at the utility scale process, it's not that they say you have to, it's just they want to know the impact before they make their decision. So a little bit different approach there.
Yeah. This next one, I have to admit, I at one point knew the answer to this, but I've since lost it because the legislation didn't move forward. And so I I try not to spend too much effort on stuff that's not real. But am I correct that House Bill 450 set a maximum community solar size at 1,000 megawatts?
No, I think there was some 10 megawatt
I,
language in there.
yeah,
Yeah, I think that was the number, if I recall
that
correctly.
sounds right, but again, when it didn't move forward, I've kind of pushed it aside and moved on. But
Yeah, they
I think
really
it was
are
10.
smaller projects. They were smaller envisioned projects in House Bill 450. Certainly not
Yeah.
as high as 1,000 megawatts.
So the
There
next
was,
one,
I think maybe what they might be getting to, Eric, is there was a total amount for the state that could be approved as community solar. And I
yes,
think that number was 2,000
I think that was
megawatts
2,000
perhaps,
megawatts.
but that
Yes,
was all of the projects
all combined. Yep.
combined. Once we reach that amount, that's it. Can't approve any additional ones.
This next one's this is an easy one to recap, I guess. And again, we've touched on this, but will we get a link to these recordings that we can share with county commissioners and or township trustees?
Yes, definitely.
The answer
You'll
is
be
that.
hearing from us once we have that page up and ready. We will email everyone with that information. And we'll also, at the same time, we should say, give you an evaluation type link that we would love for you to complete to let us know how we did and how we can improve this series and what other information you do need to get out to your local officials. So that's all coming after tomorrow's webinar.
All right, have the number of proposed utility scale solar and wind developments been reduced since SB 52 implementation? Have they increased, or is the application rate stayed the same historically? I need to go back in and kind of refilter some of that information. I think I don't know that I would say it's been reduced. I would say it's probably held pretty steady.
But according to when we had Andy on Tuesday, what he's seeing in the leasing, on the leasing side of it, is there's been change that seems to be evolving into, from the larger
Larger
projects
ones to the
to
smaller.
smaller projects on the leasing. And, that's usually our first activity that we see in a community is that leasing activity. And I think his suggestion, Eric, and you know this better than I do, was that we might be, because of PGM, because of the interconnection approvals, we might be kind of at a saturation point or reaching that saturation point, but you still see a lot in the pipeline to come, right?
Yeah,
Um,
there's still a lot of projects that are certainly backed up, I guess. Been a bottleneck in that permitting process. So
right. But what
um,
he's seeing before we get to that process is it looks like maybe some smaller projects are where there's a bit more activity now in the
yeah,
leasing side of it.
and again, those, if they go on the distribution side, would not show up in PJM. They're going to show up with the
Mm-hmm.
PUCO. Okay, I understand from your initial polling question, there are a large number of governmental attendees participating in the webinar. For those who might be at the township level, are you aware, or will you be sharing that the OTA has sample renewable energy regulations for projects less than 50 megawatts?
Yeah, and that's what I was referring to when I kept saying the model language. That's the language that I was referring to that OTA developed and circulated to townships. And to that, I think that's a good start. But the question I raised is, if you are concerned about some of these other things, that may not be enough, and you may need to amend that proposal and include more within your zoning resolution than what is circulating through that model. But I think it's a good start. But you may not be concerned about these other issues in your community, and so that could suffice.
So if a county establishes utility scale solar restriction, can it be reversed to allow solar?
Yeah, we can, any resolution that the county establishes they can pass another resolution that would remove that designation. So it's slightly different process than if it were zoning itself, and that's why it's not called zoning. It's just called a restricted area designation. So they could remove it, or through that referendum process, if it's done right away, the citizens could prevent it from even coming into effect.
Okay. Has there been a wildlife impact with utility scale solar projects?
Ooh, have you heard anything, Eric, on that?
I mean, I don't know how to answer that in terms of has there been an impact? I'm not the right person to say yes or no. I do know that, I mean, one of the conditions of the administrative code for the siting board process is that they describe
Hmm.
kind of the health, safety, land use, and wildlife impacts of these projects. I know that's something that the siting board looks at. Um, but to say, hey, it's impacted a specific aspect of wildlife, I'm hesitant to just say yes. Like I don't.
Hmm.
It's certainly something that the siting board evaluates. I mean, that's really
Yeah,
clear in the administrative code.
I would imagine there's some tracking and research going on, but I'm not aware of it or what results they've seen. Any that
And I
might
do
be
know that that
following
was
that.
something that, there were a lot of, as I had mentioned, I reviewed some of the public comments on certain cases, and that was something that we'd see come up frequently as concerns over impact to wildlife. So,
Hmm.
but I think an easy way, maybe, or another way to approach that is that we haven't seen a project denied for that reason, right? Like that's not been something that we've, at least I've seen in an application that
Hmm.
didn't move forward because of that.
Hmm.
I submitted questions via email prior to the presentation. Will those be answered via email?
Yeah, I can respond to that email. I did try to address each of those questions in the presentation, so I'll just summarize those in some written comments as well.
Okay. Can you describe the enforcement of the conditions of a certificate?
You'll be talking about that tomorrow to a certain extent, won't you, Eric? And
Yeah,
what
we'll
happens?
spend a little bit of time talking about enforcement. Yes.
Yeah, there is a process. We can tell you that in through OPSB. So we'll explain that tomorrow.
Okay. When an act of God event occurs, tornado, how are lease payments typically affected during the following period of zero generation?
Typically there is what we call a force majeure clause in a lease because that protects the developer. So that is very common to see them propose some type of reduction of payment if non-production occurs beyond a certain period of time. And that period of time can vary, but if it's offline for more than X days, due to no fault of their own, due to an act of God, then the lease payment would reduce down to a lower level since it's not producing energy. So that is something that we often see a developer proposing in a lease and asking the landowner to agree to that. I can't tell you what those numbers are, unfortunately. How it seems that they kind of go back to more toward that early lease rental amount, but a little bit higher. I don't know, Eric, if you're mindful of what those reduced payments are for
No,
force majeure.
I am not.
I'd have
Um,
to go back and take a closer look at some of those that I've seen.
the last one, as solar projects continue, should we be concerned of the loss of farmland?
Oh, well, as an agricultural attorney and member of the agricultural community, I guess I'm always concerned about the loss of farmland. And as Eric explained, I'm not sure which one, I think that was in the first one, when you start adding up those numbers, where are we now? Amount
Yeah.
of farmland converted to solar.
Yeah, I mean the stuff
Uh,
that's just the stuff that's at the siting board puts us just under 100,000 acres.
so about the size of which county was that you used as your,
At one point we did some modeling to say kind of a worst case scenario, like, and again, this is assuming everything would be developed, which is a big assumption because typically, like we talked about, what did I say, 27% of the projects that entered the PJMQ in Ohio have withdrawn. So not every project's gonna be built, but just kind of trying to put some scale to the type of backlog in the development. I think that we said there's roughly the amount of acreage in the PJMQ for Ohio Solar, it would be the land mass of Portage County.
So
So
that's
yeah.
a significant amount of acreage. And, the concerns that I hear are not just the loss of those soils, and especially our better soils, where that's occurring, and just taking that land out of production. But going beyond that, what ripple effects does that have within that agricultural community that's seeing that loss of land? We're certainly seeing concerns about competing for land. So as land is taken out, if you're an operator who's been relying upon leasing that land, and you've now lost that to a solar lease, but your operation is set up to handle more acres, you're going to be having an economic impact on that individual operation. But we also see kind of cumulative concerns about what will it do to the community itself. Will it increase competition among those operators that remain in that community, that farm in and around where that land has been taken out of production? Will it have an impact on the agricultural services in that area where we have large amounts taken out? Are we going to see the loss of some of those businesses and services that we rely upon in agriculture? So I guess the easy answer to the question is, should we be concerned? I think, if these concerns are valid, then yes, we should be concerned. But we're kind of in the thick of it and trying to see, do these things really happen? Do we see rental values increase? Do we see land values increase? Do we see a loss of services? What effects is it having on individual operations? Those are all things that I think we're trying to be mindful of and understand right now, to see what it does do. But there are certainly concerns about it out there.
Yes. So well put. Again, Peggy, I really appreciate your insight on this today. Again, I always pick up on something when I listen, as you kind of walk through the law and the rules and regulations. So again, tomorrow, please join us if you're able for our fifth and final session that we'll be wrapping this webinar series up. We'll be again starting off at 9 o'clock, and then as mentioned, for those of you who can't attend every session, once we're done, we'll certainly get these posted and share the links for everyone to access those.
All right. Thanks, everyone.
Yep. Thanks, Peggy.
You're welcome.